I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. We now have AI legislation in the United States. I think we've all been thinking it's going to come inevitably, and we all didn't expect that it was going to come out of the federal government. But I think most people thought it was going to come out of California, and surprise, surprise, no, California is not the first to have a comprehensive AI law. It is the state of Colorado. That is going to present big, important implications for all of the organizations who are looking to develop and use artificial intelligence in their businesses. And to discuss these important developments, I have invited a senior associate on our privacy and cybersecurity team, Sophie Baum, to the podcast to discuss what this means for organizations and how is it that they can begin to comply. Sophie, welcome to the podcast.
Thanks so much for having me, Scott.
Sophie, why don't we start maybe high level? What is this law and what are the key items that we should know about?
Sure. So this is a law that the governor of Colorado signed just about a week ago in mid-May called the Colorado Artificial Intelligence Act. It is the first, as you mentioned, kind of broadly scoped AI act in the US that we've seen. Similar to the EU AI Act, which I know has been making waves recently, the act takes a kind of risk-based approach and focuses on high-risk AI systems, which we'll dig into in just a couple of minutes. It requires both developers and deployers of AI systems to use reasonable care, avoid algorithmic discrimination in high-risk AI systems, make certain disclosures to both the government and the public and deployers of such systems, and to conduct risk assessments. So there's a whole suite of obligations that come with this law. Now, again, we'll talk about this in just a minute, but most of the obligations in this law do fall on deployers of AI systems, not necessarily developers, although there are some implications for them as well. So that's kind of a brief overview of the law. Maybe one more thing to note is the enforcement date. The law takes effect on February 1st, 2026. So there is a little bit of runway to prepare, but not a whole lot given the scope of the law.
Super helpful. Maybe just as I kind of think about that, important, there's obviously some unique nomenclature here around the developers and deployers. And so I'm thinking about that. The developers are going to be the organizations who are creating the AI-enabled products and services. And think of those as like the Microsofts of the world, for example. And then you have the deployers, which are going to be the users, the licensees, the folks who are going to obtain this technology from a third party and then deploy that in connection with their operations, thus deployers. Does that sound about right?
It does.
So importantly, then, if I start thinking about, all right, what do I need to do about this law? First, I need to figure out, am I a developer? Am I a deployer? Am I both? And it sounds like the obligations are going to be different depending on which hat you wear, whether you're wearing the hat of a deployer or you're wearing the hat as a developer. And maybe in many of our clients' case, you're going to be wearing both hats, but in different times.
I think that's exactly right. And one other thing to think about is what is the type of AI system that you are either developing or deploying? And the bulk of the obligations under this law focus on what it calls high-risk AI systems. And those are artificial intelligence systems that, when deployed, make or is a substantial factor in making a consequential decision. So a consequential decision is any decision that has a material or legal or similarly significant effect on the provision or denial to any consumer of or the cost or terms of education, employment, financing or lending, essential government services, healthcare services, housing, insurance, or a legal service. That's a pretty technical legal definition, as you can probably tell. I read it right off the page. But what it really means is there something that would make or break the provision of services? So would there be, for example, a decision to give somebody an educational opportunity that they wouldn't have already? Or is there a decision to lend somebody a certain amount of money or in a certain context that would otherwise be denied? And is that decision based on AI or not?
And if I'm getting it correct, those consequential decisions is as it relates to an individual, as it relates to a particular consumer, because obviously AI may be leveraged in a variety of ways that probably to think that it has an impact on a specific individual or consumer would be remote, but it would have significant impacts in connection with their internal operations.
Yep, that's exactly right.
So I think maybe a number of questions come out of this, and this is some of the same issues that we have been talking about with respect to the EU AI Act. But importantly, what I hear you saying is that we have an obligation here as we are thinking about the uses or the deployments of artificial intelligence, that we need to categorize them as to the level of risk that they would present. That risk will be determined as we are thinking about what the impact is or the consequence specifically back to individuals. My question, though, is each individual deployer of the AI free to make those determinations? Is this something that the government makes those determinations? If we make them, how are we expected to do that?
That's a great question, Scott. So it is up to the individual deployers or developers to make a determination as to whether their system is high risk. And so I think some of the things, and we'll talk about this when we talk about next steps and what organizations should do with all of the provisions of this law. But one of the things that we would expect companies to be doing is thinking through, what are the types of decisions I make? Do they have implications like some of the ones listed in that consequential decision definition of, for example, do we make decisions about education? Do we make employment decisions? Do we make decisions about healthcare, housing, insurance, other legal services? Think about whether those are things that the company is making decisions about, then the role of AI in them. And then at that point, you can conduct a risk assessment, which we'll talk about in just a second, to determine whether or not this is high risk AI and what some of the mitigating factors might be.
Okay, so are there two categories then, high risk and non-high risk? Or are there something else that falls between in the way that the EU AI Act works?
As this law is written, there are kind of high risk AI systems and everything else.
Okay, so EU AI Act says the highest levels of risk, you just can't do it. Doesn't sound like the Colorado law says you can't do it. It sounds like you need to be able to take specific actions as a result. Interested in kind of how that looks like. If I determine that there is a high risk system, what is it that I need to do? You mentioned a risk assessment. And then what does it look like if I fall in the category of a non-high risk system? What do I need to do?
Sure. So for those folks that have non-high risk systems, just general artificial intelligence systems, both deployers and developers, they need to disclose to consumers who interact with their AI systems the fact that the consumer is interacting with them, unless it would be obvious to a reasonable person. So again, not just for high-risk AI systems, but for everyone. Now, most of the obligations in this law fall on deployers and developers with respect to high-risk AI systems. And I can take those one at a time, but there is one obligation that is sort of blanket that covers both of them, and that is with respect to algorithmic discrimination. So the Act requires both developers and deployers of high-risk AI systems to use reasonable care to protect consumers from any known or reasonably foreseeable risk of algorithmic discrimination. Now, importantly, both developers and deployers can establish a rebuttable presumption that they have used reasonable care to avoid algorithmic discrimination if they comply with the requirements in the Act and any rules promulgated by the Colorado AG.
Interesting. So if I'm thinking about like how this system is going to work, and especially kind of matching it against how we are expecting things to go in the EU, is that this kind of worked out in the way that, at least I've been predicting on this podcast, is that we may not have comprehensive AI laws, but we are likely to find ourselves in the same way that the GDPR has slowly made its way to the United States in California, Colorado, and the 28 plus states that we have their comprehensive laws. In other words, there is a version of the law that is kind of was first embraced within the EU, and that was the GDPR with the privacy, or at least for privacy and data protection. Then several years later, or a few years later, it was kind of found its way into the CCPA, and then it's kind of rolled out through a number of different states with all slight differences, but keeping those core tenets in place. Sounds like we have that here, except that the EU AI Act is not yet in effect, and we may have a law in Colorado that precedes the implementation of the EU AI Act.
Yes. So the Colorado AI Act will come into effect before all of the provisions of the EU AI Act. I think importantly, Connecticut was another state that had a really advanced, very similar bill to Colorado, and that made it kind of all the way up, but didn't quite pass during the legislative session in Connecticut. And so what I think will happen is that if I had to use my crystal ball, I would say that maybe unlike what we saw with GDPR, where you had GDPR kind of filtering into the US, you have now almost two standards that are developing independently. You have the sort of Connecticut/Colorado style framework in the US, which I anticipate other states will pick up in the next year and try to run with. And then you have the EU AI Act on the other hand. Now, it's important to note, and I know that we're going to not be focused in this podcast on comparing them clause by clause necessarily. So it's important to note that there are really similar tenets or themes that are in both the EU AI Act and Colorado. So, for example, even classification of systems, you might have high risk versus something else. And so there are gradation of obligations that attach when you have different systems of different risk levels. So that's kind of one similar theme that I think we see in both laws that I anticipate we'll continue to see in the US.
And so you mentioned kind of these two pieces of legislation kind of moving side by side and operating some independently. But I think it's also the case that they're not operating in a vacuum, right? In other words, it sounds to me as though the big components of the structure and the overall framework that was integrated within the EU AI Act has made its way into the Colorado AI Act. And so as organizations are planning for what AI compliance looks like in the future, in some ways, there's going to find some similarities and then in some cases, really important differences in the same way that we see it with respect to the GDPR and the state comprehensive laws.
I think that's exactly right. And it's important too for our clients and others that are large global organizations to remember it's not just the EU and the US, right? We've seen emerging, at least generative AI regulatory frameworks in jurisdictions like China, Australia, South Korea, Japan, Singapore, and others. And so this really is going to be kind of a global effort in terms of harmonizing those frameworks and building programs that make sense for all of them.
So, Sophie, maybe you can give us next up just a high level overview. What does a developer need to do under this law? And what does a user or deployer need to do under this law?
Sure. So there's a long list, especially for deployers, but I'll do my best to kind of summarize. So developers, first of all, and we're talking again about high risk AI systems, developers of those systems need to make certain disclosures to deployers about what information they use to develop those high risk AI systems, like what training data they use, their data governance practices, et cetera. And they also need to make disclosures to deployers about information that they might need in order to complete an assessment of the high risk AI system. Developers also need to make certain statements to the public, summarizing their AI systems that they develop and describing how they manage risks related to those systems. And finally, they need to make certain disclosures to the Colorado Attorney General. Deployers, on the other hand, and again, we're talking about deployers of high-risk AI systems, have a longer list of obligations under this law. So they need to implement a risk management policy and program. They have to do, and this one is pretty important, risk assessments or impact assessments related to their AI systems, and they have 90 days to complete those after the system is launched or when there's a substantial modification to the tech that they're using. They also have a duty to annually audit each deployed high-risk AI system. They need to make certain disclosures to consumers about their systems, including the purpose and function of that system, the nature of the consequential decisions that they might be making based on that system, and other things. They also need to inform consumers of their rights under the law, or under the Colorado Privacy Act, to opt out of processing of data for profiling. They need to notify consumers about whom certain decisions are made, including the reasons for the decision, the consumer's right to correct certain inaccurate personal data that might be processed by a high-risk AI system, and the consumer's right to appeal the decision for human review if that's technically feasible. Entities also need to disclose to the public statements summarizing their use of the system, and finally, to disclose to the Colorado Attorney General the discovery of algorithmic discrimination within 90 days of that discovery. Now, importantly, there are two additional notes here. One is that there is a certain exemption for small employers. which I believe is 50 full-time employees or less. And then there's also a safe harbor for impact assessments if the deployer completes an impact assessment that is aligned with certain requirements.
So lots of things there, and probably future episodes to try to unpack each one of them. But if I'm thinking at this at a very high level, it's like, boy, we need to do analysis to try to understand the technologies that we are deploying, that we are developing. We need to be able to create, sounds like a number of written artifacts or a lot of written documentation surrounding that analysis, including the risk analysis that are associated with it. We need to go and be able to notify individuals and set up a process by which individuals are both going to be notified and be able to exercise individual rights with respect to these systems. And then we're going to have this overhang of potential conversations with our contractual partners around how our contractual partners are developing the AI that we are licensing from them, and how is it that we are going to gain access to all of this information to be able to conduct this analysis. And I also heard you say that all of it's going to be open to the government, including if we discover a problem in the form of algorithm bias, then we're going to need to actually affirmatively notify, like a breach notification requirement.
Yeah, I don't know that I would say all of it needs to be open to the government, but there are certainly particular disclosures that are required to the Colorado Attorney General.
Interesting. Well, that sounds to me like there's a lot of things to do. And what I think also it emphasizes is that as organizations have been building out and or starting to build out their AI governance programs in anticipation of what these obligations were going to look like, now there's a lot of things that need to be baked into that governance process to bring some order and logistics and, frankly, implementation around all of these requirements, which largely have never existed before this law went into place.
That's exactly right. I think there are a lot of next steps for organizations to be focused on and thinking about in the lead up to the effective date of this law. So if you are kind of any entity that uses an AI system, not necessarily high risk, but you should confirm whether you're using one, because you'll need to tell your consumers or your customers that they are interacting with an AI system. Also, I think for everyone, not just high risk AI deployers or developers, keep an eye out for future regulations from the Colorado AG. They have permissive rulemaking authority to expand the law here, but they don't have to publish anything. So that's one thing I would say. And then for deployers or developers of high risk AI systems, there are a number of things that I think would be really helpful to be thinking about at this stage. So first of all, again, it's just understanding where you are. Maybe that means doing a gap assessment between your governance program that you're beginning to build for the EU AI Act. It might be thinking about dedicated resources. A lot of times, privacy professionals are taking on this AI work. They're doing a great job, but they're very busy. There's a lot going on right now, and so they might need some additional resources or additional team members to help them manage that. Another thing I would say for this law is to look at existing risk assessment processes. So the AI risk assessments are required by this law are different, have different standards than the privacy assessments required by the Colorado Privacy Act or other privacy laws. So make sure you understand what these requirements are and you're scoping your risk assessments appropriately. Make sure you're involving the right stakeholders, because again, those folks might be different than privacy or cyber risk assessment stakeholders. And also note that these are not kind of one and done assessments. They're not a piece of paper that you write and put in a drawer. So you want to make sure that there's a process to evaluate these annually, which is required by the law, and also when to trigger them in the event that's required by the statute. So for example, if there's a material change to the tech. And final note on risk assessment processes, I would say consider conducting these under privilege. This is, again, a new process for many folks, and that's something that we're hearing a lot of clients discussing. Maybe two other quick additional points on what to take into consideration as next steps, given the new obligations under the Colorado AI Act. Another big one, in addition to risk assessments, is disclosures to consumers. So deployers that deploy high-risk AI systems, we talked about this, right? They need to make certain disclosures in the event there's a consequential decision that is adverse to the consumer. So one thing to think about is, what does that mean, an adverse consequential decision? Maybe in a policy or a standard or some other internal document. Have a real hard think about do we make these types of consequential decisions? And what does it mean for our organization for a decision to be adverse? And then also make sure that you plan, again, for those individualized disclosures that you'll need to make to consumers in the event there is an adverse decision, and also plan for all of the website disclosures, all of the other types of more general disclosures that are required by the law. And then the last category of things in terms of preparation, I would say there is a safe harbor, which we kind of touched on briefly for certain types of assessments. So make sure you understand whether your AI governance program is based on a particular standard like NIST. And if so, use that to assess whether you're able to avail yourself of the safe harbor under the law.
That's a really long list.
Yeah, sorry.
Well, not your fault, but I would imagine, many listeners who are responsible for doing all of these things say, wow, tell me again, when do I need to get all of this done?
Yesterday. No, the law goes into effect in February of 2026.
Maybe, Sophie, as we kind of bring our conversation to a close, interested in your take on how practitioners in this space can maybe easily describe what has just happened to their business contacts. In other words, as lawyers kind of working with inside of organizations are saying, wow, now there's all sorts of new stuff that needs to happen. And in some ways, the first step is I need to make sure that people appreciate what the significance of this change. Yeah. Any practice points about how to articulate this?
I think GDPR is a helpful framework in some sense. And so I would say the way that it's helpful is when you're explaining to the business, remember back in, 2018, when we were kind of doing what we wanted with data, we weren't paying that much attention to privacy, maybe, or if you were, that's excellent. But this GDPR was a really fundamental shift in the way that organizations started thinking about their data governance practices. This is a similar lightning bolt moment where you have a brand new framework, something we've never seen before, that is going to really fundamentally shift the way that companies deploy and use AI systems in their daily business. Now, importantly, I said GDPR is really helpful in some sense and maybe less helpful in others. I think a lot of folks that are not in this space, maybe, leaders in the business, but don't have the same type of legal background might say, oh, well, we already follow GDPR. So isn't this just the same? Or we already follow the Colorado Privacy Act. And isn't this kind of similar? The answer is it is kind of a fundamentally different framework. And so using GDPR as an example of saying, hey, this is something really, really different, and no, we can't just sort of bolt on to those existing practices might be a helpful talking point.
Yeah, really good point there, Sophie. Really appreciate your participation in this podcast. Always learn so much from our conversations together. So thank you for joining me.
Thanks for having me, Scott.
With that, I'm Scott Loughlin. This is the Data Chronicles, and those were your data points.